Um, are we live stream? Are they ready? Yeah. Okay. I
You're
have
live.
6 o'clock, and we need to be moving right along because Miss Yvonne has an education meeting scheduled following this meeting. We'd like to call this emergency called meeting of the Lumbee Tribe of North Carolina Tribal Council to order. Mr. Harold, would you give us an invocation?
Gracious eternal Father, we humbly thank you for you. Father, we have for our tribal council out with us. Pray tonight, Lord, for our people. All so many that's in hospitals, rest homes. So many of that hospice have been called in, but dear Heavenly Father, we've read in the book, dear Heavenly Father, but God who is able. Lord, we pray you ever just touch, Lord, the family members that someone may have lost a mother today, someone may have lost a father, Lord. You know, God, you're able. Pray you wrap your loving arms around them, dear Heavenly Father. We're living in perilous times, dear Heavenly Father, but we thank you, your grace and your mercy, dear Heavenly Father. Keep us. Let us, dear Heavenly Father, always follow you. We thank you. We love you in your precious name.
Main stand-in, Mr. Jody, would you lead us in the Pledge of Allegiance?
Pledge allegiance. Flag, United States.
Rebecca, would you lead us in the preamble?
Yes, madam. In accordance with the inherent self-governance of the Lumbee Tribe of North Carolina, the tribe adopts this Constitution for the purposes of establishing a
Tribal
tribal
government
government
structure,
structure,
preserving
preserving
for
for
all
all
time
time
the
the
Lumbee
Lumbee
way
way
of
of
life
life
and
and
community,
community,
promoting the
promoting the
educational,
educational, cultural,
cultural, social,
social,
and
and
economic
economic well-being
well-being
of
of
the
the Lumbee
Lumbee
people,
people,
and
and
securing
securing
justice and
justice and
freedom
freedom
for
for
the
the
Lumbee
Lumbee people.
people. May be seated. Madam Secretary, roll call.
Billy Oxenine,
Present.
Sharon Hunt,
Here.
Gerald Gooseby, Harold Smith,
Here.
Pam Hunt,
Here.
Jody Bullard,
Here.
Wendy Moore, Carrington Locklear, Christy Hunt,
Here.
Richard Jones, Nancy Locklear here, Yvonne Daw,
Here.
Rudy Locklear, Kathy Hunt, Joy McNeil,
Here.
Bobby Emanuel,
Here.
Chakawana Oxenine,
Here.
Josephine Doss,
Here.
Annie Taylor, Alex Baker,
Here.
Homer Fields.
Here.
Madam
Okay, I entertain a motion to excuse Mr. Richard Jones and Gerald Gooseby. They are on tribal business.
So moved.
moved.
I have a motion by Alex Baker, a second by Bill Oxenine. Favor, let it be known by saying aye.
Evercorn.
In accordance with Ethics and Conflict of Interest Ordinance 2010-0312-01, amended March the 12th, 2010, it is the duty of every council member to avoid both apparent and perceived conflicts of interest with regard to any matters before council in this business meeting. If so, please refrain from participation in those deliberations. All documents that require council action are considered confidential and shall not be disseminated until after a vote by the full council. Again, welcome to this emergency called meeting. I appreciate y'all responding so quickly and at such a late hour, getting the notice out. But thank you for being here. Miss Lakeisha, are there any community comments? There being no community comments, we are here for one item of business, which is dealing with our LTH. It's CLLR 2023 1003 01, entitled Lumbee Tribe Holdings Inc. Business Development Opportunities. And at this time, I would turn the meeting over to Mr. Josh Malcolm.
Good evening, Council. Thank you for giving us an opportunity to address you on such short notice, and I'll explain just as way of background why there is a short notice. As our LTH board knows, I, Ms. Heather, and our outside counsel, which we have retained on a number of matters, has been tracking a case that's been working its way through the federal courts in Tennessee. And the short version is this involves a case where a individual sued the SBA, sued the federal courts, and sued a number of parties, including the U.S. Department of Agriculture, Small Business Administration, Secretary of Agriculture, and the administrator of the SBA. And the case deals with the 8A program. The case involves concerns about individual 8A program participants. As a reminder, we are not an individual program participant. We're what's referred to as an entity participant, just like ANCs, Alaska Native Corporations, and NHOs, Native Hawaiian organizations. And so what's interesting about this case, really the genesis, and this is not political, this is factual, the genesis for this case, believe it or not, is directly or indirectly related to the decision involving UNC Chapel Hill, where UNC Chapel Hill was in litigation for a number of years that went to the United States Supreme Court. The United States Supreme Court recently ruled in a majority opinion that UNC Chapel Hill was not allowed to use race as a basis for admissions. That involved other schools as well, but that's what may resonate with you all because that's UNC Chapel Hill. As a result of that case, there's been a number of, there's been interest around the country related to other programs that our federal government has. And in short, that's sort of exactly what this case is about. Because for individual 8A applicants, socioeconomic disadvantaged individuals includes individuals based on their race, American Indians, Hispanics, and other folks that have gone through difficulty in their past. The case alleges that our government, the federal government, had not been adequately evaluating those and had given those individuals what's called a presumption, where they did not have to demonstrate to the federal government actual past discrimination that affected them, their livelihood, and their progress in society. What does that have to do with Lumbee Holdings? Well, what it has to do with Lumbee Holdings is because all 8A applications go through one portal. The SBA's not the most IT fancy federal agency out there. And in the middle of this case, before the case was decided, there's been a number of what I'll refer to briefly, and your counsel, and of course my counsel knows this better than I do. There's been a number of motions, preliminary motions, where the plaintiff has gone to the court, gone to the judge, and asked that the court take immediate action before the case is even heard on the facts and on the law. And the judge agreed. And so about 3.5 months ago, the judge made some decisions that resulted in SBA shutting down the 8A application portal, the same portal that we were in the process of using to file our L56 8A application. So that's been shut down. So that affects every 8A in the nation, whether individually owned or entity owned. So what's happened in the last week or so since I saw y'all a couple weeks ago? Well, we've been monitoring this. Heather and I have been talking about it outside counsel. We've gone to presentations related to it. There's been a lot of chatter at these events that I go to and that Heather participates in other ones. And we hadn't, or at least I had anticipated that the court was going to do what courts normally do and go on to trial and continue to rule on motions and things like that. I was in Leesburg, Virginia, where I had a chance to speak with the SBA's #1 lawyer about 3 weeks ago, Mr. John Klein. And I asked him, I held up my hand and I said, why can't you open the portal back up for the entities and not hold us hostage to what's happening in this federal court? And he said, because we only have one portal and it can't distinguish between entities and start answering the questions. So it shut down for everybody, which has not been to our benefit. So in the last week, and part of the reason that we're here now, and I would suggest that would request that the council take action at the request of the LTH board, is because on Friday, unbeknownst to anyone, there was no notice sent out. I told Heather I've been checking it about every 2 or 3 days. All of a sudden, about 4:30 p.m. on Friday, SBA 8A application portal opened. As soon as it opened, I sent a text to folks that assist us in that, and I said, "Hey, Megan, what in the world's going on?" And she goes, "What are you talking about?" And I said, "The 8A applications portal was open," and that's all she does. And she caught off guard. So over the weekend, I started updating, preparing documents for our L56 8A application. In the meantime, what's happened in the last 2 weeks? There's been a motion. I'll hand this to you, Heather. You can hand those out if they want to read them. It's pretty heavy legal stuff. There's been another motion filed by the plaintiff, where the plaintiff has asked the court to take additional action. So you got the SBA opening the portal on Friday. You have the SBA opening the portal on Friday. We start running, and then we see this motion that was just filed in the last, 10 or so days. They're all the same. And that led me to the conclusion, after speaking with the Lumbee Holdings board and Heather, that we don't know when and if the court is going to order SBA to close the portal again. And as a related matter, and as a timing related matter, and Daniel and Heather and I know this as practicing lawyers, there's what's called a briefing schedule. So the last brief is due in about 3 days. Once the briefs are filed with the court, with the judge takes those briefs under, quote, consideration. And in this case, he or she can do anything. And so that led me to the conclusion that it would be in our best interest, and I spoke with the Holdings board, that it would be in our best interest to get everything in the portal now, not knowing what the federal district court judge may do. As a side note, Heather and I have had discussions. To our knowledge, there has been no concerted effort among any entity association, for example, NCAID, that we collect a lot of money at the res, that's supposed to be looking out for business in native country, Indian country. They've not taken any position on this. They could have been an intervener, but they've not done that. And I'm not, and Heather's not aware of any entity or entity-owned organization that has attempted to intervene. The bottom line, what's the bottom line, Josh? The bottom line is we've prepared a draft resolution. It's not an ordinance. And of course, that's purposeful. Just like this council has passed before, you may recall, those that have been on the council for a while, you all passed a resolution back in 2020 when I came and spoke to you about Lumbee Holdings' intent to move forward and starting 2 new companies, starting companies, plural, and that resulted in us starting LITS, Lumbee Federal, and Lumbee 56 Construction, which we now refer to as Lumbee 56. And if you read the ordinance that I shared with Ms. Lakeisha and that we shared, I had Ms. Heather share that with your council. I did call Daniel yesterday out of respect for him and his new role with the council, and we did try to give him heads up that this was coming so he wouldn't be totally caught off guard. And it's my understanding that Heather sent him a copy of this draft resolution this morning. It does recite, if you read it, the whereas that goes through his historical timeline. And just know this resolution goes to SBA because we have to prove to them that the tribe is aware of what Lumbee Holdings is doing on y'all's and our tribe's behalf. So the more information that we can have in there that makes it clear to eliminate any confusion about intent, and the tribal governing board, our council, agreeing with what Lumbee Holdings is doing related to starting new businesses. That's why this may be a little more lengthy than you probably may think it needs to be. And it's basically because we're trying to lawyer it up so there's not additional questions from SBA. The language we also included in there, and this is very similar to the ordinance, the resolution that was approved a couple years ago. We cite by number and date the prior resolutions and ordinances that have been approved by the tribal council. If you skip to the end of it, and this is in follow up to, this is the other part of this riddle or this complex thing. You all may remember, those that attended at the LTH shareholders meeting, we notified the tribal council and the tribe in general that Lumbee Holdings did intend before the end of the year to start a new 8A. New 8A is going to be started in NAICS code 541611, which is why that is particularly mentioned in the last whereas on page 2 of the document. That is going to happen. For that to go through the 8A application process, which we intend to put through as well, we will have to prove to SBA that the tribal council is aware of that. This resolution is a vehicle for us to do that. I'll be happy to answer any questions or respond to any thoughts. Thank you.
Are there any questions for Mr. Malcolm? Give you a minute to look at it. It's quite lengthy.
I'd like to open the floor for debate by making a motion that we accept and approve this resolution.
Motion by Alex Baker, second by Joy McNeil. Motion, Miss Pam Hunt.
So Josh, just to clarify, this suit that has been brought, it only affects 8 days. Is it going to affect all? Or are we in jeopardy of losing our other 8A?
Yeah, that's a very good question. I'm sorry I didn't cover that. This lawsuit alleges that SBA for years has not properly admitted people to the 8A program. So they're having to go back to every 8A in the nation is having to, if they're individually owned, they're having to basically go through a short, I'll call it certification process, where they have to submit a written narrative and they have to describe instances in short instances or an instance in their life that makes them qualified to receive that rebuttable presumption. In our case, because we're entity owned, we got notice that we were under review, and then about 2.5 or 3 weeks ago, in regard to LTE and Lumbee Federal, we got notice from the SBA that we met the test as an entity-owned businesses, and therefore we did not have to submit that. So to answer your question, everybody that y'all may know that has an 8A, they're having to go hire lawyers or smart people they may know, and they're having to prepare essays and a narrative. And if they can't, And there are federal agencies. We looked at an award. I looked at an award 2 days ago with the Navy where they made very clear they will not make an award to you unless you submit a copy of the clearance letter from SBA.
Thank you.
So just for clarification for me, because I'm not 100% sure on how it's been done previously. So at the end of your the resolution, indicating that Tribal Council urges Lumbee Tribal Holdings Board of Directors to take any and all necessary steps to move creating an additional company or in creating additional companies and affiliated entities that will benefit our tribal members very soon. So has the tribal council ever been involved in that process that the Lumbee Tribal Holdings Board of Directors authorizes LTH to create new companies?
2020.
We were involved.
This same process that I'm doing tonight
So
was done in 2020.
So if this language is in here the way it's written, process be the same, or is this giving you exclusivity to go ahead and move forward without coming back before us? Because it's making me believe, or it's leading me to believe that if we pass this resolution the way it's written that way, that we're already giving you permission to go ahead and do whatever you need to do to create any future companies without coming back before the tribal council.
You're asking, and this probably won't sound the way I intend it. Our friends, Miss Wendy and I had an informal conversation this weekend. Our friends down in Oklahoma that have 60 of these have not gone to their tribal council 60 times. So to answer your question very directly, Mr. Locklear, that be it resolved does give Lumbee Holdings the authority to move forward in creating additional entities. But I would suggest to you that the part about line 5 up that starts with the word council hereby expresses its appreciation to the LTH boards for keeping the council informed of anticipated business development plans, which that's the reason I announced in July that Lumbee Holdings intended to move forward with starting a new 8A in the primary NAICS code of 541611. So here we are today telling you now we're putting it in writing. If that, I don't know if that makes at least in my thought process, that's an example of where the LTH board was keeping the tribal council informed of its anticipated business plans.
I guess just for clarity on my end, so that makes sense. I'm just concerned that the way it's written, same courtesy be carried out in the future. So when we pass this resolution and it gives you basically start new companies, and I know you said there was pass it the way it's written, will you still come to us when you start a new business, or will this go ahead and give you not having to keep us in the loop?
Just to be clear about how this process works, Joshua Malcolm, who happens to be the guy right now, makes a recommendation to Lumbee Holdings board that includes 2 of your members for approval. Before anything's moved forward, 1, they have to approve it. 2, they would have to approve an operating agreement. So that's not coming to the council, Mr. Locklear, but that's coming to the governing board. To be to cut the knife on it, you are exactly right. If 2 months from now, Lumbee Holdings makes the decision that it needs to open, let's focus on the word, you called it out a few minutes ago, affiliated entity. Let's say for some reason we need to open a nonprofit to parallel some for-profit opportunity we're going after. We may have to do that. And this would give us the authority to do that, Mr. Locklear.
Per, uh, I was looking at the same language, any and all jumped out at me and just slapped me upside of the face. It just, as much as I want 108 days. And I expressed that over the weekend that I want, because 8A actually gives the Lumbee people access to a budget or i- monies that could, in essence, override federal recognition's ability. Now, that's how important uh, economic development is to the Lumbee people, because we're under attack, as you all know. And if anything happens with regard to NCAI and them allowing that type of legislation to come forward, we will see similar actions take place and create a domino effect in the HOSTA and other funding entities that state recognized tribes rely on.
This program's under, y'all should, don't be confused. There are people in Washington attempting to change the 8A program the same way you're talking about with NCAI. The same thing's happening. The same exact thing's happening, Miss Wendy, where there's a push by some to exclude state recognized tribes from the SBA's 8A program. That's been an ongoing thing for a number of years. And the paradigm shifting in our country. I mean, I can't speak for the policymakers, but that is occurring. So you're not prophesizing. You're stating facts.
Okay. Well, as an elected member of this tribal council, it does scare the bejesus out of me to see the term any and all. Giving an outside organization the power to control the dynamic of the Lumbee economy. Period. Point blank. I'm in a dilemma with how we approach a modicum of keeping the council informed. Because as it stands, the people that sit on Lumbee Tribe Holdings aren't business gurus. Nobody's really business gurus. So I'm just saying that, I'm pausing for a minute to ingest this and digest this and see where we go.
So can I respond to that? So the only thing I'll say is if you look up at line 3, it starts with the word create additional companies which is a limitation, shall only be created for the primary purpose of creating economic benefits for the Lumbee tribe. So LTH, can't start something. That's a great example. They can't start something that's not going to create economic benefits. So if Miss Pam and Mr. John Lowry and Ricky say, hey, I want to start a Waffle House, and we know a Waffle House has failed in Pembroke, let's be honest, it did, or the equivalent of it, Huddle House, that they can attempt to run that through, but to be candid, I, in my position as the CEO, and I know Heather in her position as the general counsel, remember, our fiduciary duty is to the business, not to those individual members. So I don't know if you see that as a limitation. We did when we wrote it. That language was put in there purposefully, Miss Wendy.
Mr. Baker?
I echo the concerns, and I totally support this initiative. I want to say that up front. If you decided to drop 5 in the hopper tomorrow, I would applaud you. I say, and I would like to know, do you have a anticipated number after my comments of how many that you're looking to drop into the portal? But I am concerned, and I underlined any and all steps because that is concerning whether we are the governing board or not. And so, and while I have total faith currently in the speaker and the treasurer, their terms expire in January. And so for me to be a yes, despite the fact that I support him dropping as many in the portal today, tomorrow, and next week, I would like to see a sunset period of December the 31st, 2023 to this resolution because we do have a change of that board in January.
So this is going to sound sharp, but I'm here to state facts. I want to be crystal clear. The governing board that has the authority to take any and all necessary steps is Lumbee Holdings. It's not the tribal council. We certify that under penalty of perjury routinely. I certify that under penalty of perjury because I'm signing bank documents. So when we recently signed the letter of credit for $5 to $7 million, I'm asked to certify in writing that the Lumbee Holdings Board of Directors has the authority to take any and all necessary steps to sign that financial document. So if the tribal council tonight or any other time makes the decision that they are not comfortable with that language, this is going to crescendo. So I want to be clear to you. And if this council takes that decision, Heather for sure, because she's the lawyer, me as the CEO, will have a duty to notify our bank that Lumbee Holdings Board of Directors does not have the authority. And all of that is a domino effect. That's one concern. If the concern is about starting 30 companies, which I think is sort of what Mr. Locklear's, if I'm interpreting his question right, may have been his concern. There may be some language that we could put in there if you want that says can start additional companies up through maybe perhaps some fictional stick in the sand date of the last day of June of 2024 or something akin to that. And that would require us to come back to the tribal council if that was the desire of this board. This document has to go to SBA, and it has to say that Lumbee Holdings, who's applying for the SBA program, has the authority to apply for it. That type of language is in there purposeful. That any and all steps. And if you look at, we're just focused on this last paragraph. I mean, if you look at the whereas is way up above that, you'll see where this resolution recites what's in the Lumbee Holdings bylaws, which says they have the authority to take action under North Carolina corporate law. That's the other thing to remember now. Unlike all of our federal friends in Indian country, save a few, all of their companies like ours are formed under the Indian Reorganization Act, Section 17. We're not. We're just like a normal company that's formed in North Carolina. We just happen to have the ability to be able to apply to the 8A program. I don't know if that's helpful, Mr. Baker or Ms. Moore or Mr. Locklear.
Will you finish? Because if it's something different, I was going to
No,
move to Mr. Bill.
it's along the same lines because I don't want to be misunderstood that I have a concern about any and all. I understand that they have that jurisdiction already by being the board of directors. This resolution is a resolution of support for this action. And so, we're not contesting their authority as a board to do any and all, and you're empowered to sign on their behalf. I just think, I underlined that. I had that any and all concern. And this resolution as written lives in perpetuity. And I think that was the current concern. The portal's not going to be open, it sounds like, and this case is going to be solved one way or another.
We have no idea when it may close or the judge may rule, and that's really the reason we came so quickly, because we just don't
'cause
know.
you just don't know. And so I want to be clear on that respect that I'm not questioning any and all here, but it's the perpetuity of the resolution. And, we support this measure during this circumstance. And I appreciate you. And that's the only reason why I asked for more or less a sunset clause on the show of support for this particular action at this particular time, and not to be invoked 3 years down the road after this case may be settled. And Josh, you might not be there. We might not have someone of your integrity and your caliber to come and to keep us apprised. And we would surely have a different board. And so I don't want this to come back and bite me right when I'm getting ready to get off, and someone starts a heroin clinic and says, "Well, we have this support that we can do any and all economic development at this time." That's my only concern, is if we had put something in that says this supports them, we affirm their any and all ability and their right as the board of directors for our 8A, but this support for this limited action is limited for this time period. That's all that I was asking.
Mr. Bill.
On this comment we've been talking about, I'd just like to see a time period put in those jobs. And then that way it keep both sides informed, updated. Thank you.
Neil?
Basically, this is just a common courtesy for LTH to come to.
It's not a common courtesy. This document must be submitted. We have to show in writing a number of things. So there's a number of things. The tribe or the tribe's representative has to show that it's going to financially back this new company, L56. We're talking about L56. Lumbee Holdings is stepping in y'all's shoes. Why do I want Lumbee Holdings stepping in y'all's shoes? Because if the tribe does it, I got to ask for y'all's financials. Y'all don't want y'all's financials turned over to other people. So there's other things too, Mr. Dewitt. This is just one example. We've got the other things covered. We have to submit something showing unmistakably that the tribal council is aware of Lumbee Holdings' actions.
And can I call for question, because we've been on this topic?
Well, I want everybody to be very comfortable. So, Ms. Christie.
Mr. Malcolm, so if we put a limitation in here, could that look like, could that be perceived as who we're sending it to in a negative tone, almost like, that's just how I see it. I mean, I agree, but I'm saying if we say giving it to you for June of 2024, to me, on the outside looking in, it would be like they're only entrusting you to make decisions until June of 2024, and not being able to make sound judgment as we entrust you to moving forward.
When I threw out that date, I was just using that example. I can't tell you how somebody's going to interpret it. I can tell you how other circumstances that I've been in, and that's very similar to how it's been interpreted. But that's up to this council to decide. That's why y'all are the council.
Mr. McNeil.
Comments, Mr. Daniel, since you're new on board representing us.
First of all, I understand moving forward from Lumbee Tribal Holdings. Secondly, I think what's recited in the resolution, essentially what he just covered, and that it becomes necessary as the governing body that they provide how they are given the authority to act, and that's prescribed in their resolution. And I think ultimately, accountability of Long Beach Tribal Holdings is going to be to the council. Secondly, big picture is that an entity being created for the economic benefit. I would ask the question, ultimately, what is the downside of that? Before we get bogged down in the nuances of resolution wording, I think that the fiduciary duty and the responsibility of tribal holdings and its core is that they promote Columbia economic interest. They can't act outside of that. So anything that they're going to do, it can and only be for that purpose. Since it's only for that purpose, since they've recited how they have the authority already given by the council to make these actions, I think that yes, you read it any and all, but it's in operation already. It may not be denoted anywhere as any and all, but they have to do what they have to do to get the job done. You've already given them the power to do so. Boarding requirement, from what I can tell, and I hadn't gone through everything, that because the government requires them to have this board's basically giving them the authority to act on your behalf. That's why they've recounted what they have in the resolution. Ultimately, they can't act outside of the fiduciary duty that you have a responsibility. Already given them the authority to act, and only the actions they can take is for the economic interest. So it doesn't. I don't want it to sound like circular reasoning, but they can only do what they've been prescribed to do from the beginning. You've been given them the authority in the beginning to do these actions. So ultimately, there is no downside, I don't think, for the board, whether we say they can open as many entities as they want. Sure, that's a good thing. You want them to open the entities because they're already a review process that they already have in place to make sure that they are of economic interest, and that's why you have a board. I think if you want to move a step forward, you can, I don't know what the accountability is from those council members that sit on the board to report to the council. That might be something you want to look at to require a quarterly or annual reporting by those members that you already have on the council that's sitting on the board who's overseeing these operations. And they can explain to the board what actions are being taken. And I think at that point, if there was some need or cause for concern, then you would make those motions. But up until then, the way I read it is it's a necessary function for them to be able to operate under SBA's guidelines. So either you're gonna you allow them to operate the way they need to, or you're gonna put a hamper on their ability to engage.
Okay, Ms. Wendy?
That being said, Mr. Locklear, Mr. Malcolm referred back to the bylaws, and that would be just fine if I had ever got to see the bylaws. Okay? So you're saying give you full authority to do what you need to do to create the economic benefit for the Lumbee tribe, but yet we don't know how you're operating under your bylaws or your operating agreement. So how do we in good faith do that? You tell me that.
Wait, want to make sure, Miss Wendy, I'm thinking the bylaws we've turned over to you all, and each quarter when I come in section 2, without me looking at CLLO 2020-0326-01, which is referenced, you would, everyone, if you look at the whereas that's on the bottom of page 2, third whereas from the bottom, page 2, the third whereas from the bottom, whereas LTNC passed 0326. So we have to come, or I come on board, the boards have to do this financial reporting requirement. Section 2 of the 7 things that I have to report is any changes to the LTH bylaws. The last change that was made to the LTH bylaws, and the only change that's been made since 2021, has been the inclusion of a conflict of interest provision that I think we recently talked about at one of your meetings in closed session. So the LTH bylaws I can send a version of that to the speaker. That's something we've shared before. If you all want to see that again, what you've not seen and what is not public and what we don't disclose is our operating agreement, because that has business information in it. That's, Miss Wendy, that may be what you're thinking about, the operating agreements, and each entity has their own operating agreement, although L56s and Lumbee Federals are exactly the same.
Anything further?
Roll call.
Billy Yass,
Yes.
Sharon Hunt,
I recuse myself.
Gerald Gooseby, Harold Smith,
Yes.
Pam Hunt,
I recuse myself.
Jody Bullard,
Yes.
Wendy Moore,
Yes.
Carrington Locklear, Christy Hunt,
Yes.
Richard Jones, Nancy Locklear, yes. Yvonne Dahl, Rudy Locklear, Kathy Hunt, Joy McNeil,
Yes.
Bobby Emanuel,
Yes.
Chakawana Oxendine,
Yes.
Josephine Dawes,
Yes.
Annie Taylor, Alex Baker,
Yes.
Homer Fields.
Yes.
Motion carries.
Thank you very much, Council.
So for the record, for those who are listening by live stream, the resolution that was just voted on, CLLR 2023-1003-01, the therefore is be it resolved that the Tribal Council of the Lumbee Tribe of North Carolina hereby acknowledges the authority vested in the LTH Board, which is Lumbee Tribal Holdings, to create additional companies which shall only be created for primary purpose of creating economic benefits for the Lumbee Tribe of North Carolina. The Tribal Council hereby expresses its appreciation to the Lumbee Tribe Holdings Board of Directors for keeping the Tribal Council informed of its anticipated business development plans for the creation of additional companies in compliance with any applicable state or federal law. The Tribal Council hereby urges the LTH Board of Directors to take any or all necessary steps to move expeditiously in creating additional companies and affiliated entities that will benefit our tribal members very soon through business development opportunities. Finally, the Tribal Council hereby urges the LTH Board of Directors to create jobs and small business opportunities for our skilled, talented, and committed tribal members living in our territory as it decides which contracts or business opportunities to pursue. That was the resolution that was just passed. There being no further business, I entertain a motion to adjourn.
John.
Got a motion to adjourn. All in favor? Thank you all. Mr. Homer, would you close us in a benediction?
Fathers, we come to you this evening. We ask you, Father, just to
Before we get started,